Hi, my name is Jaquise Powell. Welcome to my research case study presentation. Thank you so much for watching and I hope you enjoy. Here we go. We're going to start off with part 1 featuring the New York Times versus Sullivan. The parties in this case include the plaintiff, who is a commissioner from Alabama named L.B. Sullivan, and the defendant, who is the New York Times. L.B. Sullivan is suing the New York Times because of an advertisement that discussed police actions during the civil rights movement. Sullivan feels that he is a representative of the police, so all of the derogatory comments about the police in this article he felt were aimed at him. Therefore, he felt the need to file a libel claim. Sullivan felt that the New York Times damaged his reputation due to the fact that outsiders would not want to be associated with Sullivan due to the associations of himself with the police. He brought a witness to the stand. This witness was a former employer. The former employer told the court that if he were in fact in accordance or believed in all of the mentionings of the police in the advertisement, if he believed that these mentionings were in fact true, he would not want to be associated with Sullivan or any other individual that participated in such acts. None of the witnesses that testified in this trial ever mentioned that they believed any of the story mentioned in the article. In order to prove libel, a person must prove that statements made were in fact derogatory or defamatory. Also, they must prove that the statements were made about themselves. The Supreme Court decided to rule on the behalf of the New York Times. They felt that Sullivan could not prove that the statements made were out of malice. They also felt that it was their duty to uphold the constitutional rights of the New York Times, which in fact include the First Amendment and the 14th Amendment. They include the right of freedom of speech and they include the freedom of the press. The second part of this series is going to include Gertz versus Welch, a case that I actually was very intrigued in due to the dramatic nature of said case. The parties in this case include Robert Welch, who is the petitioner, and Robert Welch, who is the respondent, and Gertz, who is the petitioner. In this case, the petitioner was not a public figure. In this case, a magazine ended up attacking the reputation of the attorney and published false information about his character. The respondent wrote that Nucio's murder trial was a conspiracy and that this trial was only meant to discredit the police. The respondent also used name-calling tactics and implied that the petitioner was a criminal. Nothing was done to confirm any of the allegations mentioned. In my personal opinion, I do believe that these allegations impacted Gertz. I believe that, as mentioned in the article, private individuals are more vulnerable to injury because they do not have access to the press as easily. Therefore, they are not able to defend themselves in a more public light. I feel that individuals who are constantly in the public light are able to defend themselves much more easily. If I were Welch, in order to avoid a lawsuit, I would not resort to name calling. I would not resort to name calling. I would bring my point across, and I would treat this platform as a way to, in fact, inform, but form opinions, and throw opinions and make these known that this is my opinions, or throw thoughts, but definitely not to accuse anyone of being any communist or any other name that person would find derogatory. I would not resort to any type of name calling tactics. In the state of Florida, there need to be 4 present elements in order for a defamation claim to be brought to court. These 4 elements are: a false statement must have been published, the statement must have been made about the person suing, the statements must have been made to a third party, which could be a person, which could be the press, which could be a written document. And the 4th one is the false information in the statement must have impacted the reputation of the person filing the suit. From reading these 2 cases, I've learned that when writing articles, it is very necessary to be mindful of what information you put in your article. I've learned that it's very easy to take information the wrong way. Therefore, it's important to fact check your information. I've also learned that opinions are okay as long as they are not judgments, as long as they are not finger pointing remarks that could damage a person's character. Thank you so much for watching my presentation, and I hope that you've enjoyed this, and I will see you in my next presentation.